The morning of October 14, 2019, started like any other Monday in Jefferson County Courthouse. The heavy doors swung open to the smell of old wood and bureaucracy, the sound of shoes clicking against marble floors, the muted conversations of attorneys shuffling papers, and the distant hum of a city that had long ago decided who mattered and who didn't. For most people walking through those doors, the courthouse was a place of procedure, a machine that processed human lives like paperwork. But for Marissa Williams, a 34-year-old black woman in a burgundy blazer carrying a folder stuffed with years of hard work, it was supposed to be the beginning of something new. It was supposed to be the day she proved what she was made of. Marissa had passed the bar exam on her second attempt, a fact that still made her chest swell with quiet pride. She had studied at night, at kitchen tables while her daughter slept, in laundromats between cycles, in the parking lots of grocery stores where she worked double shifts to keep the lights on. She was not born into law. She had fought her way into it. And today, she was scheduled to appear before Judge Harold Simmons for a preliminary hearing in a wrongful termination case she was arguing on behalf of a black warehouse worker named Darnell Porter, who'd been fired for insubordination after he complained about racial harassment from a white supervisor. The case was straightforward, she believed. The evidence was clear. The pattern was unmistakable. She had done this before. Small cases, procedural hearings, nothing splashy, but this felt different. This felt like one of those moments where the law could actually be what it promised to be. Blind, fair, resolute. She believed in the law the way some people believe in religion. Not naively, not without scars, but with a deep, stubborn conviction that justice, when fought for hard enough, could still be real. She believed in the law the way some people believe in religion. Not naively, not without scars, but with a deep, stubborn conviction that justice could still be real. The courtroom was half full when she arrived. She took her seat at the plaintiff's table, arranged her documents, and nodded to opposing counsel. A sharp-suited man named Bradford Quinn who had the look of someone who had never once doubted his right to take up space. Darnell Porter sat beside her, nervous, wearing his best clothes. She squeezed his arm once. "We've got this," she said. He nodded, though his eyes said he wasn't sure he believed it. What happened next was not a legal argument. It was not a procedural dispute. It was not even really about the case at hand. What happened next was one of those ruptures in ordinary time, the kind that reshapes everything that comes after it. It began with two court officers, both white, both large, who approached the plaintiff's table with the slow, deliberate confidence of men who had never once been questioned. One of them put a hand on Darnell Porter's shoulder. The other looked at Marissa. "Ma'am," the officer said, "you're going to need to move. This table is for counsel only." Marissa looked up. She held up her bar card. "I am counsel," she said evenly. "I'm representing the plaintiff." A silence fell. Not the silence of confusion, the silence of decision. The officer looked at Bradford Quinn. Quinn's face did not change. The officer's hand moved first. "Hey." The slap was not a slap in the traditional sense. It was an open-palmed shove to the side of her face, a motion that carried with it every assumption that man had ever held about who deserved to stand in a courtroom. The folder in her hands went flying. Papers cascaded across the floor like white birds scattering from a gunshot. Darnell Porter was on his feet instantly, hands up, instinct and terror competing for control of his body. The courtroom erupted. Judge Simmons hit his gavel once, twice, 3 times. Marissa did not fall. She stood there, hand pressed to her cheek, and the thing that everyone in that courtroom would remember later, the thing that made this story go from local news to national reckoning, was that she did not cry. She turned slowly, deliberately, and she looked at the judge. Then she looked at Bradford Quinn. Then she looked directly into the small camera mounted near the back wall that was recording court proceedings. And then, after a long breath, she sat down, picked up her papers one by one, and said, in a voice that did not shake, "Your Honor, I'd like to continue." That moment, captured on footage that would be shared 7 million times in the next 48 hours, was the beginning. Not of her story. Her story had already been being written for 34 years. But of the chapter where the world finally started paying attention. To understand what happened in that courtroom, you have to understand where Marissa Williams came from. You have to go back to the Ensley neighborhood of Birmingham, Alabama, a neighborhood that had once been the industrial heart of the South, where steel mills had hummed with a kind of terrible, muscular purpose, and where black families had built entire worlds in the shadows of those mills. Churches and barbershops, Friday night fish fries and Saturday morning hair salons, block parties and block watch committees, a whole culture of survival dressed up as celebration. By the time Marissa was born in 1985, those mills were mostly gone. What remained was the residue of their departure. Unemployment, underfunded schools, neighborhoods that the city had quietly decided were expendable. Her mother, Gloria Williams, worked 2 jobs, cleaning offices downtown from 5 a.m. to noon, then cashiering at a grocery store from 2 p.m. to 9 p.m. Her father, Raymond, had been a good man undone by a bad economy and a worse relationship with alcohol. He left when Marissa was 6. She remembered him mostly as a smell, Old Spice and something sharper, and as the particular quality of silence that filled the apartment after he stopped coming home. Gloria Williams did not raise her daughter to be bitter. She raised her to be clear-eyed. "The world is going to tell you things about yourself," she used to say, braiding Marissa's hair in the mornings before school. "And most of what it tells you will be wrong. Your job is to know the difference." It was a kind of epistemology passed down through hands and hair, through the press of a comb and the pull of a braid, a way of knowing yourself so well that the world's lies couldn't get a foothold. The world is going to tell you things about yourself, and most of what it tells you will be wrong. Your job is to know the difference. Gloria Williams. Marissa was a good student, then a great one. She read everything: library books, church bulletins, the backs of cereal boxes, the legal notices in the local newspaper that she found oddly fascinating in their formal, declarative certainty. There was something about the language of law that called to her even then. It was a language that claimed to be fair. She wanted to see if it was true. She went to the University of Alabama at Birmingham on a Pell Grant and scholarships she'd hunted down one by one, applying for everything, writing essays in the school computer lab at midnight. She majored in political science, minored in African American studies, and worked 20 hours a week at a hotel front desk where she learned how to be simultaneously invisible and indispensable. A skill that, she would later reflect, turned out to be excellent preparation for being a black woman in a predominantly white profession. She was accepted to Samford University's Cumberland School of Law in 2010. She was 25 years old, a single mother to her 4-year-old daughter Zora, and she had approximately $400 in her savings account. Her mother watched Zora while Marissa attended classes. She studied during Zora's nap times. She studied on the bus. She studied in the bathroom stall during her lunch breaks at the hotel, where she continued working part-time because there was no other option. She failed her first bar exam attempt in 2013 by 11 points. She cried for 1 day, then she went back to the books. She passed on the second attempt in 2014. The day she found out, she called her mother first. Then she sat in her car in the parking lot of the Walgreens where she'd bought the paper to take the exam, and she laughed until she cried. Zora, then 8 years old, was in the back seat doing homework. "Mama, why are you crying?" Zora asked. Marissa turned around and looked at her daughter. This child who had come into the world with no instruction manual and every need, and said, "Because sometimes the thing you've been fighting for finally says yes." Hey. She opened a small solo practice in 2016. 1 room in a shared office space in Woodlawn, a second-hand desk, a printer that jammed every 3rd page, and a reputation that she built the only way available to her. 1 client at a time, 1 case at a time, 1 Saturday at a time when other attorneys were golfing, and she was in her office preparing arguments for people who couldn't afford to pay her much but needed someone who would not give up on them. Employment discrimination, landlord-tenant disputes, child custody, immigration paperwork for families who needed a translator in more than one sense of the word. She took what came and she did the work with full seriousness, understanding that for the people who walked through her door, a lawyer wasn't an abstraction. She was the difference between staying and going, between working and not, between a family intact and a family broken. This was who walked into Jefferson County Courthouse on October 14, 2019. Not a symbol, not a cause. A woman who had spent her entire life earning the right to stand in that room, hold that folder, make that argument. The officer who raised his hand to her face did not see any of that. He saw what he had always been trained to see, or rather, what he had always been trained not to see. And that invisibility, that willful structural blindness, was exactly what was about to cost him everything. The courthouse camera captured 12 seconds. In those 12 seconds, Officer Dale Pruitt, a 17-year veteran of the Jefferson County Sheriff's Office, approached the plaintiff's table, exchanged words with Marissa Williams, and then made contact with the left side of her face in what investigators would later describe as a deliberate open-hand strike to the facial region. 12 seconds. The kind of clip that rewires a national nervous system. The video was posted to Twitter at 6:47 p.m. by a courthouse employee who had watched it on the court's internal monitoring system and, in a decision they would later describe as the most important thing I've ever done at my job, extracted a clip and uploaded it without identifying themselves. Within 3 hours, it had been viewed 1.2 million times. By midnight, it was 4.7 million. By the following morning, it was everywhere, every major news network, every social media platform, every group chat in America that had ever discussed race and law and power in the same breath. What made the video so shattering was not just what it showed. It was what it showed in context. This was not a street corner. This was not a traffic stop. This was a courtroom, the physical space that American society has designated as the home of justice, the place where the rule of law is supposed to be most inviolable. And within that space, a black woman attorney, bar card in hand, suit pressed, argument prepared, doing exactly what she had been licensed to do, had been struck across the face by a white uniformed officer who had, as the clip made unmistakably clear, simply not believed she belonged there. This was the physical space that American society calls the home of justice. And inside it, a black woman attorney had been struck across the face for daring to stand there. The reactions came fast and from everywhere. The Alabama State Bar put out a statement within 4 hours of the video going viral, calling it deeply troubling and promising a review. The Jefferson County Sheriff's Office initially released a statement saying Officer Pruitt had been responding to a perceived security threat, a formulation so disconnected from what the video showed that it seemed to generate more outrage than the original incident. 3 former presidents tweeted. Oprah shared the clip with a single word: enough. Legal organizations from the NAACP Legal Defense Fund to the American Bar Association issued statements calling for immediate accountability. But the response that cut through all the noise was simpler and came from closer to home. Marissa Williams' daughter Zora, then 13 years old, posted a photo on Instagram of her mother's bar certificate, the framed document that hung in their hallway, with the caption, "She earned this. She worked her whole life for this. Touch her again and the whole country will know your name." The post was shared 800,000 times. Media requests flooded in overnight. Marissa herself gave no statement that first day. She went home, made dinner, helped Zora with homework, and called her mother. "What are you going to do?" Gloria asked. There was a long pause on the line. Then Marissa said something that would later become the title of the documentary made about her case. "I'm going to finish what I started." The next morning, she filed 3 separate legal actions. First, a formal bar complaint against Officer Pruitt. Second, a civil rights lawsuit under Section 1983 of the Civil Rights Act, naming Pruitt, the Jefferson County Sheriff's Office, and the county itself as defendants, alleging racial discrimination and unlawful use of force. Third, and this was the move that no one saw coming, she filed a formal judicial complaint against Judge Harold Simmons for his failure to intervene during the assault on an officer of the court, arguing that his silence in the moment constituted a dereliction of his duty to maintain order and protect the participants in his courtroom regardless of their race. That third filing detonated a secondary explosion of attention. Legal scholars appeared on television to debate whether it was viable. A Harvard law professor wrote an op-ed in the Washington Post arguing it was not only legally sound but long overdue. A former Alabama judge wrote a counter-op-ed calling it a political stunt masquerading as jurisprudence. The debate filled cable news for days. Meanwhile, Marissa returned to court. A different courtroom, a different judge, temporary reassignment, and won her wrongful termination case for Darnell Porter. He was awarded $210,000 in damages. She charged him $1,500 in fees. "He can pay me the rest when he can," she told reporters outside the courthouse. Someone in the crowd started clapping. Then more people joined. It was not a triumphant moment, exactly. It was quieter than that, more like a release of something held too long. The kind of sound that comes when a held breath finally finds air. The weeks after the video went viral had the texture of a siege. Marissa Williams became simultaneously the most visible and the most vulnerable she had ever been in her life. Fame, she discovered quickly, is a kind of pressure system. It compresses everything and everyone around you, and the people it brings out are not always the ones you choose. Death threats arrived in her email within 48 hours of the video going viral. Some were crude. Some were elaborate. All of them carried the same basic message. You stepped out of your place, and there will be consequences. She forwarded them to the FBI without comment and kept working. The legal machinery moved with the grinding slowness that characterizes systems that are not eager to hold themselves accountable. Officer Pruitt was placed on administrative leave with pay, a formulation that struck many observers as precisely the wrong message. The sheriff's office retained an outside law firm that had represented them in 17 previous excessive force cases, a fact that Marissa's attorneys flagged in their initial filings. Judge Simmons recused himself from all future involvement in her cases, which was widely understood as the minimum possible response to a complaint that called his conduct into direct question. The Alabama State Bar's review, promised within days, stretched into weeks without a formal finding. But Marissa had a strategy, and it was not the strategy anyone expected. She did not seek the maximum public confrontation at every turn. She was not interested in performance. She was interested in precedent. Every motion she filed, every action she took, she was thinking 10 steps ahead. What does this establish? What door does this open? What does this make impossible to ignore next time? She was not interested in performance. She was interested in precedent. Every motion filed, every action taken, what does this establish? What door does this open? The Section 1983 lawsuit moved forward. Discovery revealed something that Marissa had suspected but could not have fully anticipated. Officer Pruitt had been the subject of 4 previous internal complaints in his 17-year career, all of them from black individuals, all of them resolved with no disciplinary action and no public record. A black man had filed a complaint in 2008 alleging Pruitt had pushed him against a wall in a hallway outside a hearing room. A black woman attorney, not Marissa, a different attorney, had filed a complaint in 2015 alleging Pruitt had told her she was in the wrong place when she appeared in court to represent a client. That complaint had been dismissed. The woman in question, when contacted by Marissa's investigators, said she had not pursued it further because she'd been told informally that making waves would affect her ability to get cases scheduled. She was one of only 12 black attorneys practicing in Jefferson County at the time. She couldn't afford to be blacklisted. This pattern, documented, systematic, invisible until someone made it impossible to ignore, became the heart of Marissa's civil case. She was not arguing that one officer had one bad day. She was arguing that the Jefferson County Courthouse operated a system of implicit exclusion, enforced by officers who had never been disciplined for enforcing it, supervised by judges who had never intervened, and funded by a county that had never once audited whether black attorneys received the same treatment as white attorneys in its courtrooms. It was, legal scholars noted, one of the most ambitious civil rights arguments made in Alabama courts in years. Whether it would work was another question entirely. Alabama is a state where the judiciary and the law enforcement establishment are deeply intertwined, both politically and in terms of the social networks that determine whose calls get returned, whose motions get heard on time, and whose cases get scheduled in the courtrooms with adequate lighting. Marissa knew all of this. She had grown up watching it. She filed anyway. The political response was equally complicated. The mayor of Birmingham issued a statement of concern. The governor's office released a 3-sentence response calling for due process, language that, when applied to the process of holding a law enforcement officer accountable, functioned more as a delay tactic than a commitment. 2 state legislators introduced a bill that would have required annual training for court officers on the rights of attorneys of record. It died in committee within 6 weeks. A national black attorneys advocacy group called Courtroom launched a campaign using Marissa's case as its centerpiece, and in doing so, she acquired allies she had not asked for but was grateful to have. Through all of it, she continued to practice law. She took new clients. She won cases. She showed up to every scheduled appearance in every courthouse in Jefferson County without security, without a handler, without a press team. Just herself, her briefcase, and the bar card that she now wore on a lanyard so no one could ever again tell her she didn't belong in the room. A colleague asked her once if she was scared going back. "Every day," she said. But scared isn't the same as stopped. That distinction, small and enormous at once, was the whole story point. One of the most complicated and least discussed aspects of Marissa Williams' fight was the question of who showed up to stand beside her and who chose, for various reasons, to remain at a careful distance. Public support was enormous and genuine, but the texture of that support was uneven in ways that revealed as much about American institutions as the original incident had. The legal community's response was instructive. The American Bar Association sent a formal letter of solidarity. Several prominent civil rights attorneys offered pro bono assistance with her cases. Law school clinics reached out to offer research support. These were meaningful, and Marissa accepted them gratefully. But within Alabama itself, among the attorneys who worked in the same courthouses, filed in the same courts, knew the same judges, the response was more muted. Many expressed private support. Fewer were willing to attach their names publicly. The ones who were most cautious, Marissa noticed, were often other black attorneys. People who understood better than anyone what the informal consequences of making waves could look like in a small, closed professional community. She did not judge them for it. She understood the calculus. But she felt the weight of their silence in a particular way, the way you feel the absence of something you needed. Her most unexpected ally was a white attorney named Patricia Holbrook, 62 years old, a veteran of Jefferson County's courts who had been practicing for 34 years and had, by her own admission, spent most of that career not looking too closely at the dynamics that Marissa was now forcing into the light. Patricia called Marissa 2 days after the video went viral. "I've worked in that building for 3 decades, she said. "I saw things I should have said something about. I didn't. I want to help now if you'll let me." Marissa let her. Patricia became one of her co-counsels on the civil rights case and used her deep knowledge of the local legal community to navigate procedural obstacles that might have derailed a less strategically supported filing. "I've worked in that building for 3 decades. I saw things I should have said something about. I didn't. I want to help now if you'll let me." Patricia Holbrook. The media attention brought its own complicated dynamics. Every major outlet wanted the story, but they wanted it in particular shapes. They wanted the tear, the breakdown, the moment of visible suffering that would confirm the story's emotional stakes. Marissa, who did not perform suffering for cameras, found this frustrating. "They keep waiting for me to cry on television," she told her mother. "Like my pain isn't real unless they can watch it." She did several interviews, carefully chosen, with outlets and journalists she trusted to present context rather than spectacle. And in each one, she steered the conversation away from her own trauma and toward the structural questions. What policies allowed this? What accountability mechanisms had failed? What did change actually require? The community response in Birmingham was deep and personal in a way that national attention couldn't replicate. Women who had faced similar moments in their professional lives. The security guard who'd questioned whether they belonged, the colleague who'd assumed they were support staff, the client who'd asked to speak to the real lawyer, flooded her inbox with messages. A group of black women attorneys in Birmingham formed a support circle that met monthly at a church basement. Marissa attended when she could. "Those meetings," she said later, "were the thing that sustained her through the long months when the legal process moved at its usual glacial pace, and the daily emotional labor of being a public symbol, while also being a working attorney and a mother was almost more than one person could carry." Darnell Porter, the client whose case had been interrupted by the assault, became, unexpectedly, one of her most visible advocates. With the $210,000 settlement from his case, he launched a small foundation focused on legal assistance for black workers facing racial discrimination in Alabama workplaces. He named it the Williams Justice Fund. Marissa learned about it from a news article. She called him immediately, both touched and alarmed. "You didn't have to do that," she said. "No," he agreed. "But you didn't have to believe me when no one else would either. We get to choose what we do with the things we've been given." The foundation raised $340,000 in its first year. Its first grant went to a Birmingham legal aid organization that Marissa had been volunteering with for years. The money funded 2 additional attorney positions, one of which, in a detail that did not escape anyone's attention, was filled by a young black woman fresh out of law school who had watched the courthouse video on her laptop in a law school library and decided, in that moment, that she was going to become an attorney. The trial of Marissa Williams' civil rights case against Officer Dale Pruitt, the Jefferson County Sheriff's Office, and Jefferson County began on March 3, 2021, 16 months after the incident in the courthouse. By then, the country had been through a summer of reckoning unlike any in recent memory. George Floyd had been killed. Breonna Taylor had been killed. Ahmaud Arbery had been killed. The nation had watched, argued, protested, and remained perpetually, exhaustingly unresolved on the question of whether the United States of America was capable of applying its own stated principles to the people it had historically excluded from them. Into this context arrived Marissa Williams versus Pruitt et al., a case that was, on its surface, about a courtroom assault but that was, in its deeper logic, about the entire architecture of how racial exclusion operates within legal institutions. The arguments Marissa's legal team made were carefully constructed and deeply researched. They established the pattern of prior complaints against Pruitt. They introduced expert testimony from a criminologist who had studied racial disparities in courthouse security behavior and found statistically significant evidence that black attorneys were more likely than white attorneys to have their credentials questioned by court officers. They presented testimony from 6 other black attorneys who had experienced similar moments of being challenged, redirected, or questioned in Jefferson County courtrooms. The defense argued that Pruitt's action had been a reasonable response to what he perceived as a security situation, that his record as a 17-year veteran spoke to his general character, and that the incident, while regrettable, did not constitute a pattern of civil rights violations but rather an isolated error in judgment made in a fast-moving, ambiguous situation. Their expert witnesses were credible. Their arguments were professionally made. And against the video footage, they were structurally incapable of succeeding. The defense argued isolated error in judgment, but against 16 years of pattern evidence and 12 seconds of footage, that argument had nowhere to stand. The most significant testimony of the trial came not from any expert but from Marissa herself. She took the stand on the 4th day and spoke for 3 hours. She spoke about the morning of October 14th with the precision and clarity of someone who had replayed it thousands of times in her mind. She spoke about her bar card. She spoke about what it meant to be a black woman attorney in Alabama in 2019, the specific combination of hypervisibility and invisibility, the way she was simultaneously conspicuous as a person and invisible as a professional. She spoke about her daughter Zora watching the footage on a phone. She spoke about the letters her mother had written in the aftermath of the incident, letters to the sheriff, to the county commission, to the governor's office, each one polite and precise and met with silence or form responses. And then she said something that the courtroom went very still for. "I am not here for sympathy," she told the jury. "I am not here to make anyone feel guilty for history they did not personally create. I am here because the law of this country says that what happened to me should not be able to happen, and when it does happen, there should be consequences. Not because it will undo what was done. Nothing undoes what was done. But because consequence is the only mechanism by which systems learn. And this system needs to learn." The jury deliberated for 11 hours across 2 days. They returned a verdict for the plaintiff on all counts. Officer Pruitt was found liable for civil rights violations under Section 1983. The Jefferson County Sheriff's Office was found liable for its failure to adequately train and supervise its officers with respect to the civil rights of attorneys of record. Jefferson County was found liable for its systemic failure to implement and enforce non-discriminatory practices in its courthouse. The total damages awarded were $1.4 million, $400,000 in compensatory damages, and $1 million in punitive damages, a figure the jury foreman later said was chosen deliberately to be large enough that it could not be absorbed as a cost of doing business. Marissa sat at the plaintiff's table and did not move when the verdict was read. Then she turned to Patricia Holbrook beside her and said, quietly, Okay. Holbrook's eyes were wet. Marissa's were dry. It was not that she wasn't moved. It was that she had learned, a long time ago, to save her tears for the moments where they were truly hers alone to spend. The appointment came 18 months after the verdict, in September of 2022. Governor Kay Ivey announced the appointment of Marissa D. Williams to the Jefferson County Circuit Court, filling a vacancy created by the retirement of a judge who had served for 22 years. The announcement was made at a press conference that Marissa attended with her daughter Zora, her mother Gloria, and Patricia Holbrook. She wore a dark blue suit. She smiled, not the calculated smile of a politician, but the slightly overwhelmed smile of a person who has arrived somewhere they genuinely did not know they would reach. The appointment was politically significant in several layers that the coverage only partially captured. Jefferson County's Circuit Court had never had a black woman judge. The state of Alabama had had fewer than a dozen black women serve as judges at any level in its history. The appointment was not, its critics noted, a response to political pressure. Governor Ivey had in fact been one of the more measured voices during the controversy, neither loudly condemning the incident nor loudly defending the officers, navigating the political terrain with the careful neutrality of someone who understood that the issue was too large and too charged to be useful to her if she took a strong public position. But whatever her motives, the appointment was real, and its symbolism was inescapable. The confirmation hearings were intense. State legislators questioned her about her views on law enforcement, on judicial temperament, on the appropriate role of a judge in addressing systemic inequality. She answered every question with specificity and calm. She was asked, by one legislator, whether she could be fair to law enforcement officers who appeared before her in her court given what had happened to her. She paused for a long moment before answering. Then she said, "The question you're asking assumes that my experience makes me less capable of fairness. I'd invite you to consider whether the experience of never having your credentials questioned, never having your right to be in a room challenged, might also affect a judge's capacity for fairness, in the other direction. The question assumes my experience makes me less capable of fairness. Consider whether never being challenged might affect fairness in the other direction." Judge Williams at confirmation. She was confirmed by a vote of 22 to 11. The 11 votes against her were cast by legislators who cited various procedural and qualification concerns, each of which legal observers noted was substantially weaker than the objections routinely set aside for other nominees. But 22 was enough. The morning of her swearing in ceremony, Zora, now 16 years old, taller than her mother, with her grandmother's eyes, helped Marissa fasten her robe. Gloria Williams sat in the front row. Patricia Holbrook sat beside her. Darnell Porter was in the third row with members of the Williams Justice Fund Board. The courtroom was full. The room where Marissa Williams was sworn in as a judge of the Jefferson County Circuit Court was not the same room where she had been struck across the face 3 years earlier. That room was down the hall, still in use, still processing the ordinary machinery of justice. But it was close enough that when the swearing-in ceremony concluded and the assembled crowd applauded, everyone in the room knew exactly what distance had been traveled. It was not a long hallway. It was a very long hallway. It was the longest hallway in America, and she had walked its entire length without being stopped. On her first day presiding over cases, Judge Marissa Williams called the first case at 9:02 a.m. A slip-and-fall civil dispute, entirely unremarkable. The plaintiff's attorney was a young black man in his first year of solo practice. He was visibly nervous. When he rose to speak, she could see him unconsciously reach to touch his bar card, the instinctive gesture of someone who has been made to prove himself in rooms where he was not expected. She let him find his footing before saying anything. Then she said, "Counselor, whenever you're ready." 3 words. The entire weight of what they carried in that moment was not visible in the transcript. But it was real. There is a version of this story that ends with the swearing-in ceremony, with the robe and the gavel and the applause, and leaves you with a feeling of clean completion, the arc bending as advertised toward justice. Marissa Williams herself would be the first to push back on that version. "I'm one person," she said in a speech at the University of Alabama School of Law in November 2022, 2 months after taking the bench. "One case doesn't change a system. One appointment doesn't close a gap. What happened to me made visible something that had always been there. The question is whether we are going to use that visibility to actually build something different, or whether we're going to feel good about the story and go back to normal. This refusal to allow her story to function as a resolution rather than a prompt is, arguably, the most important thing about her. It is also the thing that makes her the most challenging figure in this story for those who would prefer that justice function as a finite transaction. You pay the fine, you serve the sentence, the wound is healed, we move on. Marissa does not believe in that model, because she has seen what happens in the years after the cameras go away. She has watched other high-profile cases fade from national consciousness while the structural conditions that produced them remained unchanged. She has watched the friends and colleagues who were in the courtroom that October morning continue to navigate the same courthouse with the same ambient anxiety about whether this would be the day someone decided they didn't belong. Officer Dale Pruitt retired with his full pension 6 months after the civil rights verdict. He gave no public statement. His departure from the force was reported in a 2-paragraph item in the local paper. The Jefferson County Sheriff's Office implemented new training protocols as required by the terms of the verdict, 8 hours of annual training for all court officers on the legal rights of attorneys of record. Whether those 8 hours change anything material is a question that will take years to answer, because systems change slowly and often only under sustained pressure, and pressure is hard to sustain when the story has technically concluded. One case doesn't change a system. What happened to me made visible something that had always been there. The question is whether we use that visibility to build something different. Judge Williams has used her position to do what she said she would do. Build something different, one decision at a time. In her first year on the bench, she issued rulings in several employment discrimination cases that broke with local precedent in ways that have been appealed and are working their way through the system. She has been consistent in ensuring that all attorneys who appear in her courtroom are treated with identical professional respect regardless of race, regardless of how they look, regardless of whether they went to a name-brand law school or passed the bar on their 3rd attempt while working 2 jobs. This sounds like a minimum. In a place where the minimum had not been consistently met, it is a renovation. She also established, through her foundation and through partnerships with Alabama law schools, a mentorship pipeline for Black students interested in law, pairing first-year students with practicing attorneys, providing scholarship support, running mock trial programs in Birmingham high schools. The program has sent 37 students to law school in its first 2 years. Several are already practicing. One is clerking for a federal judge in the 11th Circuit. The work is slow. The work is the point. Zora Williams, now in her senior year of high school, has told her mother she wants to be an attorney. Not because of the story or not only because of it. Because she grew up watching what it looked like to do difficult, important work without flinching from its difficulty. And she found it the most compelling thing she had ever seen. Marissa has told her to think carefully, to know what she's choosing, to understand that the courtroom can be a place of meaning and a place of cost, often at the same time. And then, she told her daughter, if you still want it, go get it, all the way. Zora smiled at that. I know, she said. You kind of showed me how. Judge Marissa D. Williams' nameplate was installed on the door of courtroom 4B on a Tuesday morning in late October 2022. It was a small brass plate, standard issue, identical to every other nameplate on every other courtroom door in the building. Her name in clean black letters. Her title. The room number. Nothing ornate. Nothing that announced itself as significant. Just a name. Just a fact. She stood in the hallway and looked at it for a long time before going in. A court clerk walking by slowed, seemed to recognize her, and then kept walking, which was exactly what she wanted. She was not there for a ceremony. She was there to work. The work of a judge, it turns out, is not glamorous. It is a daily navigation of human complexity in a context that demands a particular kind of discipline. The discipline of deciding without rushing, of hearing fully before judging, of applying principle even when it would be more personally satisfying to apply feeling. Marissa had known this intellectually before she took the bench. She learned it in her body in the months that followed, the specific weight of a judgment that affects a person's life, the careful labor of writing opinions that are clear about their reasoning, the management of a docket that never empties, the constant, irreducible responsibility of being the person in the room who is supposed to be fair. She thought sometimes, in the moments between cases, about what fairness really required. Not the legal definition, She knew that cold. But the deeper thing, the thing her mother had been trying to teach her at the kitchen table with a comb and a braid. You have to know yourself so well that the world's lies can't get a foothold. She had not always managed it. She had carried fear into rooms and sometimes let it slow her down. She had felt the doubt that comes with being told in 100 small ways that you are out of place. But she had kept moving and moving and moving until the place that had once been out of reach was the place she came to every morning and sat down in and called her own. You have to know yourself so well that the world's lies can't get a foothold. Gloria Williams. A lesson braided in at the kitchen table. A lesson that built a judge. This story is not ultimately about a slap. A slap is a moment. What this story is about is the 34 years before the slap, and the 3 years after it, and the decades to come that will be shaped, in ways both visible and invisible, by what one woman decided to do when the world tried to send her backwards. It is about the choice, made over and over and over again, to refuse the version of yourself that the world is offering and to insist on the truer one. It is about the radical, exhausting, necessary work of being exactly who you are in rooms that were not built for you, until the room has to reckon with your presence, until the room has to change. It is about a girl in Birmingham who read legal notices in the newspaper and felt something stir. A sense that language could be used for precision, for justice, that words could be arranged into arguments that held power accountable. It is about a mother braiding hair in the morning and transmitting knowledge through her hands. It is about a woman alone in a parking lot, laughing and crying at the same time, because the thing she had been fighting for had finally said yes. It is about a folder of papers cascading across a courtroom floor and a woman who bent down, picked up every single page, sat back down and said, "I'd like to continue." It is about a nameplate on a door. A brass plate, standard issue. Just a name. Just a fact. The most ordinary, extraordinary thing. A black woman's name on the door of her courtroom, in the building where they tried to tell her she didn't belong. Her name is Marissa D. Williams. She is a judge. She was always going to be a judge. The only question was whether the world was going to get out of the way fast enough, or whether she was going to have to move it herself. History will record which one happened. The people who were there already know. For every person who has ever been told, in a conference room, a courtroom, a classroom, a corner office, or a room of any kind, that they are in the wrong place. This story is not a promise that the road will be short. It is a promise that the road can be walked, that the door with your name on it exists, that getting there is not the end of the work, it is the beginning of the better kind. The gavel comes down, the room comes to order, the work begins again. It always does. That is exactly the point.